and the one who made the proposal was a rat. So there was only one rat in the ministry, no other rats. At the time of fixing fan, I had a glance of him, but I did not pay attention to him.
So just to confirm, this rat who fixed the fan and made the proposal, is this the man who would become your husband?
That is correct. That was a rat. He is now my husband.
Okay, and you said that he made a proposal to you. Can you tell me more about the circumstances of that proposal?
He was in a unit at the Ministry of Finance, away from my ministry. One night, the chief of female unit from his ministry came to my ministry, and I was called and asked, "Comrade, Angka wanted to marry you. What did you have to say?" But the one who proposed to marry you was a rat from a ministry in charge of international commerce. And I replied that I was not mature yet. I wanted to work. I did not want to marry any man. And the female chief said that no matter what you said, Angka has to agree with Angka, and Angka would organize the marriage for you. You had to respect Angka and adhere to the principles or direction set by Angka. And I was told then that in the next morning I did not have to go to work. I would receive some clothes, and then the day after, in the morning, I went to do some little work, that is growing a vegetable, and at around 9 a.m. I was given a toothpaste, Lux soap, and some detergent, washing detergent, and some other stuff. I received all those stuff.
Okay, Madam Witness. If I understood correctly, what you've said is that your chief discussed with you the proposal, but that your chief told you that the proposal was coming from this person named Rut, who later became your husband. My question is, have you ever spoken to your husband, since you've been married, about why he made the proposal to you?
I asked him. He said that he had not known me in advance before the period. He said he had heard of my name. I also asked him why he proposed me. He says that he was told of the name T that he had to marry. So I did not know him, as I said.
Okay, now let's talk a little bit about the wedding ceremony. Yesterday at 14:25, in answering a question from the prosecutor, you said that before your wedding day, you were told not to work and rest, as you would have to be involved in a marriage ceremony the next day. Who advised you not to work and rest instead?
Comrade Im, chief of a unit at the Ministry of Finance in charge of international commerce. That woman came to tell me, although I refused. She explained to me the reasons, and she told me that the next morning it was the day of my marriage, and I did not need to go to work, and I was told as well that I would be given clothes and also some other stuff at around 9 a.m. the next morning.
Did Comrade Im tell you why it was important to rest and not work before being involved in a marriage ceremony?
I did not know the reason. She only told me like that. She told me that I did not need to go out to work because it would be the day of my marriage.
Okay. Now, yesterday at 14:31, you were talking about the circumstances of the marriage ceremony. You said that your family members were not there, your parents were not aware of your marriage. There were the would-be husband and wives there, together with the organizers of the wedding, Tarit, Tahong, and two of your direct supervisors. Now, you said that your parents and family members were not there. Did the parents, relatives, or friends or of any of the other 21 couples attend the wedding ceremony?
On the day of the marriage, there were no relatives or siblings attended it. There were only those who were matched up to be spouse, and the ceremony was attended by the leadership of the place. And as for parents and siblings, they were not aware that their children were married on that day.
So does that also extend to the parents and siblings of the 21 couples? They were also not aware of the marriages that day.
All the 21 couples who were married on the same day with me, none of them had their relatives attending the ceremony.
Okay, I'm trying to understand this, so maybe I'll try a different way. Do you know if the parents or relatives of any of the other 21 couples were consulted or otherwise involved in the decision for those couples to get married?
All the parents and relatives of the 21 couples who were married were at the cooperatives. They did not come to attend the ceremony.
Did you know if they knew about the marriages in advance?
They did not know because they were at their respective cooperatives while their children were based in the city, and they received no news about the marriage.
Okay, I'll move on to my next line of questioning. Yesterday at 14:28, in answering a question from the prosecutor, you said that at that time you did not want to have a husband, and that's why you refused. Since 1975, you kept refusing, but by 1978, you could no longer do that. You wanted to be by yourself, and you did not want to get married. But on that day, despite your refusal, you were told that despite your refusal, Angkar would organize it, and you had to respect the discipline by Angkar. And you said something similar this morning. Now, the part that I'm interested in is the part where you said that since 1975, you kept refusing. What did you mean by this?
I mean that since 1974, while I was still at the cooperative at the Sesor office, the district committee brought me to a study session at the district office. And after 3 days of study session, I saw handicapped people were transported in from Sreicho district. They were brought in 3 or 4 horse carts, and they lost legs and arms. And then the next day, he talked about the marriage. He said that he came here to teach about politics, about policy of the Angka, and that we should follow the line of Angka. And he also said that the handicapped soldiers who were transported in were meant to marry to all of us. And he asked us whether we agreed to marry them. And some of the handicapped people said that they did not want to get married to the woman because the women were too young. So if they get married to them, they would not have a good future. And that was the first request about marriage.
And at that time, did you also refuse to get married to the handicapped soldiers?
At that time, he only told all of us who attended the study session. But because the handicapped people refused to get married to us, so he just left it aside. He did not take any further action. And the handicapped soldiers were returned back to their respective units. And all of those handicapped soldiers were old. And they said that they did not want to get married to us because we were too young. The future after marriage would not be successful if the marriage took place.
Okay, and you were describing that as something that happened in 1974. Now, after the liberation of Phnom Penh in 1975, and all the way until you were actually married to your husband Rat, were there any other occasions when you were proposed to be married?
In 1975, I do not remember the date. There were female chiefs in charge of supervising our group. She asked us, when we were based at Psa Thmai in Phnom Penh, she asked me that a marriage proposal was made to her to get married to me. And she asked me whether I wanted to get married. I told her that I was still young, I did not want to get married yet. And she said that, so you don't respect Angka? And then I said, no, I respect Angka. But talking about marriage, I do not want to think about it yet because I'm still young and still want to work for Angka.
And what was her reaction to you when you said that?
She reacted. She told me a few things. She said that she scolded me that I did not follow the line of Angka, I did not respect Angka, but I did not dare to respond back to her. I kept silent.
So she scolded you, but did anything else happen to you after that?
No, there was nothing happening. there was nothing happening since that time until 1978.
Now I'm up to my last line of questions, and this relates to the other couples that you were married alongside, the 21 other couples. Yesterday afternoon, at 14:22, you said to the prosecutor you were talking about your marriage in November 1978. And you said that all people in your group actually got engaged a month or two previously, but for you, you were asked that evening, but you refused. And then later, in answering a question from the civil party lawyers at 15:45, you said that before the wedding, the 20 couples knew about the plan to marry a month before. First, I want to check. When you said that all the people in your group got engaged a month or two previously, were you referring to the 20 other couples who were part of your marriage ceremony?
Among the 20 couples, about 1 month or 2 months before the marriage, they proposed to each other first. But the males and females did not meet each other personally. It was their respective chief who asked them. And then the chiefs would tell to the male side that the female side agreed to the marriage. But they did not inform yet about the exact date of marriage. And after that, the marriage ceremony was arranged. I did not know about the marriage ceremony for me. I was informed only in the evening, and then the next day the marriage ceremony took place.
Okay, so just one follow-up question on that. Not talking about you, but the other 20 women that were involved in the marriage ceremony. To your understanding, did they express their agreement through their unit chief to get married about a month before the marriage ceremony?
They told their respective chiefs that they agreed to get married, and that's why this ceremony was arranged for them.
And my last question to you is, do you know about anyone who during the DK period was able to marry someone that they chose?
At that time, we cannot choose our partner by ourselves. It happened only when there was a proposal from the man to us. There was no relationship, prior relationship before the marriage.
Thank you for your patience, Madam Witness. Mr. President, I have no further questions.
President, thank you, Counsel. And next, the floor is given to Defense Counsel for Kilsampon.
Oui, merci, Monsieur le Président.
Thank you, Mr. President. Good morning, everyone. Good morning, Madam Witness. I have only a few short questions to put to you in regard to a question that was put to you this morning by Judge Lavergne. You referred to the fact that when you taught certain children, when you were in charge of teaching them, you were asked to tell the children to pay attention to the enemy, and you stated that it was because grenades had been thrown at the Ministry of Commerce. Can you specify the event you're referring to and what you heard in that regard?
It did not happen at the Ministry of It did not happen at the Ministry of Commerce. It happened at the cooperatives. And at the cooperative where I was based, it was close to the forest. And there were spies who came in to spy on us. And the spy called in aeroplane to bomb on us. And the cooperative chief told the children to be vigilant about any spy that they would see.
Et c'était de quelle coopérative dont...
What cooperative are you talking of in particular, and where was it located?
At Sesor office. It was located near the National Road. And at that Sesor office, it was to the west of a road, and it was close, adjacent to a forest.
J'ai compris de votre réponse.
I understood from your previous answer that you talked of the presence of a plane. Did you hear the plane and did you see it?
The planes came to bomb in the area near our base. At that time, I was about 200 meters away from where the bomb fell. And before the plane came to bomb, I saw militiamen came to build the road, came to build the bridge, because the bridge had been cut previously. And then while they were building the bridge, there were two planes came in circulating the area, and then they dropped bombs. And that's why the chief of the area told us to be vigilant for enemies or spies. And he said that one day he saw a cow running into the forest. And then about 3 days later, a plane came to bomb the area. And that was what he told us.
Et est-ce que vous vous souvenez à quelle date?
And do you recall on what date that incident occurred?
I cannot recall it because it happened in 1974.
Donc c'était avant?
So that was prior to the fall of Phnom Penh, is that correct?
Yes, it happened before we were sent to the battlefield.
Je vous remercie. Je n'ai pas de...
Thank you. I do not have any further questions, Mr. President.
President, thank you, Council. The hearing of testimony of witness Pan Hin now is concluded. The Chamber would like to thank you, Madam Pan Hin. We thank you for your time here, for the two-day session here. Your presence at the courtroom now is not required. Court officer, in collaboration with vessel official, please make necessary transport arrangement to send Madam Pan him to her home.
As the Chamber informed the parties already by email of the senior legal officer of the trial chamber on 29 August 2016, that after the conclusion of Pan Hum, the chamber will hear oral submission of parties in relation to the summons of the witness to CE 93. The chamber requested parties to provide any remarks on two issues. Number one, Do the Nguyen Jie defense and co-prosecutor maintain their request to hear her testimony? Number 2, if it is so, on which specific facts would you propose to hear her testimony? Given the apparent uncertainty surrounding the figures in her report, the Chamber requests party to clarify how her testimony would be suitable to prove these facts. That is in accordance with Internal Rule 87.3c. First, the floor is given to the co-prosecutors to make oral submissions on the 2 particular questions. You may now proceed.
Thank you, Mr. President. Good morning, Your Honors. The view of the co-prosecutors at this time is that we do not consider it necessary to call to TCE 93 any longer as a trial witness. This is in view of some of the factors in your memo and other considerations. First, considering that we are in the last stages of this trial, the memo discusses that the expert had requested to be able to do additional analysis that would require months. We obviously do not favor any delay of this trial to update this previous report, given where we are and that we are close to the completion of this trial. Second, with respect to the other observation of the Chamber, the comments about the uncertainty, I would note that any demographic analysis by nature has a range of uncertainty. There is always a plus and minus range of certainty of any type of statistical analysis of this nature, of course. What we do observe, though, is that this report was, I guess if you will, not based on the original statistical work of the author, but rather was more a compilation and analysis in which it took the readers and provides to your honors, of course, an analysis of all the available demographic analysis that has been done on the death numbers from the Democratic Kampuchea regime. I think that is a relevant consideration because the author herself didn't perform the underlying statistical work, is relying on other sources which are laid out, I think, fairly clearly and discussed in the report. I think that consideration as well is one for us that hearing live testimony from this expert may not bring a lot more than what is already in the report itself. Given that, our current view is that it is not necessary to call this expert as a witness. Of course, we don't have any objection should the Chamber view it helpful to call this individual, but at this time we don't consider it unnecessary.
President, thank you, co-prosecutor. And the floor is now given to the defense team for Mr. Nguyen Jie to have some views on the particular questions.
Yes, my colleague is a bit smaller, so I need to adjust a bit, Mr. President. Good morning, Your Honours. Yes, we do have, in fact, quite a bit to say about the question whether this demographics expert should come to testify, yes or no. As the Chamber is aware, but not necessarily the public, is that there is a very long, extensive procedural history regarding this expert. It is, I think, good to remind everyone that it was the New and Chia defense team that already in October 2008, that is almost 8 years ago, asked for a demographics expert to be appointed. It has always been, and still is, a very important issue to the New and Chia defense team. Why? Because for many reasons, which I do not have to go into detail now, we do not accept the parameters that are set by various demographic experts in the past. We feel that the numbers of excess deaths and direct deaths, indirect deaths attributed to the DK regime are way excessive. There are other reports that we believe are much more reliable. So with that very, very short summary in the background, it was the reason that we asked the co-investigating judges to appoint a demographic expert, which they did in 2009. That particular expert that we are now discussing, as the Chamber is aware, came with a report which was not only by us but also by the Ingsari defense team and at a later stage also by the Kyu Sampan team heavily criticized for many reasons, methodological flaws, but also matters arose in relation to her independence and impartiality because she was a prosecutor's office employee within the ICTY. That issue has been extensively debated in the pre-trial stage. What I think is important to bring back into the memory of all parties and the Chamber that we filed a 26th request for investigative action in which we asked to appoint, we asked the OCIJ to appoint a second expert. For many reasons, we believe that was necessary. There's a very interesting decision, and it's also quite readable and useful from Judge Yu Leng and Marcel Le Monde. It is document D356/1, in which all our arguments are summarized and of course also subsequently rejected. So with this background and knowledge, we went into the trial 002/01 and we filed a request to have this particular expert testify as a witness or an expert. As we all know, that didn't happen in 002/01. Unfortunately, I might add. However, what did happen was that the trial chamber, in its judgment, came to a factual finding about excess deaths of between 1.5 and 2 million people during the DK era. I refer the chamber to paragraph 174 of the judgment, We have appealed this factual finding in document F16, which is our appeal, in paragraphs 222, 223, and 224. We argue that the Chamber, and I quote, flagrantly erred in law, violating our client's right to fair notice of the crimes charged and to confront the evidence against him. We believe that the finding of the Chamber in respect of the amount of people that allegedly died during DK was improper. We also argued that there were additional errors, and I refer to paragraph 224, and let me quote from that paragraph of our appeal brief. It says, alternatively, the trial chamber erred in fact in making this finding, the finding that there were between 1.5 and 2 million excess deaths, based on the limited record. The trial chamber, we say itself, noted that estimates of deaths in the DK era vary between 600,000 and 3 million, representing, I quote again, a preposterous difference of approximately 2.4 million deaths between the lowest and highest intervals. We presume and we hope and we anticipate that the Supreme Court chamber will issue a ruling on this error in fact and error in law. So I briefly discussed the beginning of this factual and legal debate and the end. What I should, of course, also mention is, and that is responding to what the prosecution just has said, that in 2015 we have asked the Chamber to expedite the appearance of this expert. While we were at the segment, during the segment of treatment of the charm in the Vietnamese, we thought it would be very appropriate to have her called as an expert. As the Chamber is aware, this request was denied. Leading now to the situation that we are indeed close to the end of these proceedings, and that now, because of additional publications, it might be difficult to have her come and testify in time. That is quite tragic in the light of the 8 years of procedural history in terms of the demographics. So there should be no doubt whatsoever, Mr. President, that the issue of demographics, the issue of how many people died during the DK regime, but also very important, how many people died between 1970 and 75, and how many people died in 1979 and subsequently, is a crucial, fundamental issue for the defense. Now, having said that, where should we go practically? Bearing in mind that we believe that 2 TCE 93 is unqualified as an expert. We feel it might be interesting to explore an alternative option, and that is to see if the Chamber would be willing to investigate whether the person that the expert referred to would be able to testify as an expert. And that is someone, I believe, of French origin, and now teaching at the University of California, and who actually published this article in 2015 about excess deaths during DK. Whether he should be able and willing to come instead of this expert. I'm referring to, in French, I think, Patrick Eveline. He is the person having written that article in 2015, which is particularly about decay and the periods before and after. It's this article that the other expert was supposed to take into consideration in order to update her report. So the question, considering the importance of this subject to the new interior defense team, why not change and not ask for 2 TCE 93, but instead, considering his recent involvement in demographic research in decay, call Mr. or Professor Eveline as an expert. I think he came to certain conclusions which the defense doesn't agree with, but we should at least be able in public to once have this discussion. It's almost 9 years since the case against our client has started. There hasn't been any single debate in public, in a courtroom, about how many people died because of decay policies. How many of those deaths were, in fact, violent deaths? How many deaths were indirect? Of course, we accept that there will always be a measure of uncertainty, but at least it is a subject that is very much worthwhile to having been debated in public. As we all know, justice must be done, but justice must also be seen to be done. So, realizing this short notice, but considering the procedural background, considering the importance of this subject to the new interior defense team, we would like to give into consideration to the trial chamber to, instead of summoning to TCE 93, summoning Professor Eveline from the University of California. One last thing that I would like to add, which I forgot to say. The importance of an expert testifying on demographics has been considerably augmented since another expert recently refused to testify. Many conclusions of Michael Vickery were conclusions that the defense shared, especially conclusions in respect of the number of casualties of Cham people. We had prepared for him our questions, which were, if I would make an estimate, were about 80% relating to demographics. Him not coming to testify is an additional reason that we should absolutely, before we close the evidentiary hearings, have an expert on demographics come into this courtroom and ask and answer all the questions that are still remaining. Thank you.
Can I just ask a question? First, a remark. Obviously, in the context of these trials, there are many interesting things that might merit public debate, but I think by now we all agree we should concentrate on those that are legally directly relevant, and might very well be that issues that are historically important or relevant cannot be debated in this trial. So I want to focus this whole debate from it's interesting, it should be discussed, the public needs to know on the legal issues. This is just as a preliminary remark. Can I just ask Counsel, have you actually read the Eveline article, and which part of it do you think would further clarify? We have obviously read it, yes, there is some fine-tuning, but which part of it would be so interesting that you think it sheds light on important factors?
Well, one of the factors which troubles us the most is the heavy reliance on exhumation reports from DC Chem drafted by Craig Atchison, reports that it seems Evelyn is also relying upon. If we were able to establish with him fundamental flaws in these exhumation researches, it would be very interesting if he would then, having accepted these potential new factors, whether he would agree with us that that number should go down. What is also very important is that he seems to speak not so much about deaths that can only be attributed to the period 75-79, but he seems to be speaking about the period 1970-1979, because that's the only really relevant period that one can even come to certain conclusions. In this light, it is very important for us to be able to discuss in public the impact of the United States bombing on Cambodia between 67 and 73, the impact of the Civil War. There are many issues which we believe are important to discuss with him. Now of course, I understand that at the end of the day, for legal findings, it doesn't make a difference whether there were 800,000 violent deaths or 500,000 or 100,000. But the same argument, of course, goes to the amount of people that were detained and executed subsequently in S21. But then, of course, the question is why bother having this trial at all? It is something that always comes up. It's the first thing that one sees when you Google Democratic Kampuchea. It's 1.8, 2 million. We believe this is highly exaggerated, and I think the Cambodian public and the international community deserves to have a proper debate. Whether that ultimately leads to the legal conclusions that we seek, I understand why you're saying this, but does that mean that we then shouldn't be discussing this? No. I think this is a very important subject. It goes directly to how the world views the democratic Kampuchea regime. If the number is way more down than experts say, then it is very important to Nguyen Chia, and I'm certainly also to Khieu Samphan, that the regime should not necessarily be seen in a different light than, for instance, the 1965 Indonesia regime in terms of casualties. So it's maybe strictly speaking legally not of a consequence, but factually, historically, and certainly for my client, something very important.
Yeah, I think that was an important clarification. I think we all accept that the trial also has a historic dimension, but in the end we might have to live with the fact that not all historic questions that don't have specific legal connotation might be clarifiable in this trial. There are decades to come for historians who I'm sure will go through through all of the material. I think one thing, since we are talking in the public, one of the problems here is that the only hard data or not the only, but the two major hard data we are having are 36 years apart. These are the two censuses, one from 1962 and I think the other from 1998. In between, there was a civil war, there was a Khmer Rouge period, there was the the Vietnamese occupation. So lots of things that were obviously to blame for the so far lack of any really, what do you call it, I'm not saying reliable, but clearer picture of this period. But I think I've understood your arguments. Thank you.
President, Judge Lavench, you may now proceed.
Yes, first of all, I have a question to the Nuntia defense. The defense of Nuntia brought up the fact that it had asked the co-investigating judges that another expert be appointed other than the one that was already appointed, and that it was the 26th request which was then rejected by the co-investigating judges. I would like to know if this order refusing the appointment of a new demographic expert was then appealed.
I am not certain, but I do not believe so. I will have that checked. It might be because there was a similar request, as I said earlier, from the Ieng Sary defense team to have another expert appointed. They appealed, and the pretrial chamber did come to a ruling, but only a procedural ruling, not a ruling on the content. Whether we have appealed the 1 April 2010 decision, to be honest, I cannot answer the question right now, but I'm sure we will be able to do so shortly.
The second thing is more an observation than a question. If I correctly heard the version in French of your proposal, Mr. Capet, is the Chamber express itself in case file 2.1, retaining the figures of the number of deaths under the democratic and I reread paragraph 174, which I think is the paragraph that you referred to. The Chamber there refers to the numbers that were represented by experts, but the Chamber does not express itself or make any decision in that regard.
Well, we do not agree with this, Judge Lavergne. As laid out in our appeal brief, we are saying that paragraph 174 of the judgment amounts to a factual finding that there were excess deaths of between 1.5 and 2 million people during the DK era. Because, and that's the argument that we make, and let me quote ourselves, since the trial chamber stated affirmingly that, quote unquote, experts accept the accuracy of this suggested range of excess deaths, and then did not refer to it again, much less dispute it at any other point in the judgment. So by affirmingly stating that, quote unquote, experts accept this, we have argued in appeal that this was a factual finding that consequently flagrantly erring in law. Well, whether you agree with this or not, of course, is up to the is at this stage maybe not so important anymore. We have to wait for the Supreme Court chamber whether they agree with us, yes or no.
What is important, Mr. Copé, is that we look at the facts and the decisions exactly. When we say that the experts accept these figures, this does not mean that the chamber accepts these figures.
Well, I can read it again, but we do not agree with the way it was phrased in the judgment, and the fact that there was no discussion about it, there was no reference made to our earlier arguments. Because of this, we have interpreted the ruling, or the paragraph 174, as a factual finding, which flagrantly erred in law, hence our appeal. If we see it incorrectly, then I'm sure the Supreme Court chamber will reject our appeal on this particular point. But this is how we interpreted paragraph 174. And while I'm at it, this is something that I haven't mentioned earlier, but recently I became aware of an interview that Judge Fens gave on the 15th of January 2010, and the way Judge Fens, I presume her personal opinion, viewed the amounts of deaths within DK as 1.8, it seems to me that that is indeed what the view of the chamber is. I'm happy to read it in German, but Judge Fens says, why did 1.8 million people have to die in Cambodia? Because there were 1.8 million deaths, there were also many perpetrators. So there's no really qualification, according to the judge on the bench, in her, what I presume is personal opinion. There were 1.8 violent deaths during DK. So how we should read exactly paragraph 174, of course that's up to the Supreme Court chamber, but to us it is clear.
And Judge Vance rendered the verdict in case 2.
True, but still.
I'm usually very careful in interviews, so I don't remember this particular one because it's probably, 6 years ago.
Shall I read it back to you?
No, not necessarily, certainly not parts of it. But having said that, just to clarify exactly, because we have talked a lot, the answers to our memorandum. So you do not uphold the request to hear Eva Tabor, but you make a request to appoint Mr. Hövelin as an expert, and the fact you wish to prove is general excess deaths, general as opposed to minority excess deaths, because he obviously doesn't say anything about that. Did I understand that correctly?
To be completely accurate and to be precise, what should be investigated is laid down in our fifth investigative request, our sixth request for investigative action, and our appeal against your finding. These three documents in combination, that is what should be established by a demographic expert. So we are of the view that an expert should not limit her or himself to the amount of deaths among Cham people or Vietnamese people, but should make findings or have findings, and those findings should be discussed in relation to all excess direct or indirect deaths during decay, before decay, and after decay.
But I don't think he makes findings about Chams and that Cham and Vietnamese, or I've overread something.
No, not in his last 2015 publication, but he has also written quite extensively in 1998. And his article written is extensively used. So it's not only his 2015 publication. I'm looking for the exact title, but it might be also in one of your footnotes. Yes, it is indeed. In footnote 523 of the judgment, reference is made to P. Huveline between 1 and 3 million towards the demographic reconstruction of a decade of Cambodian history. It actually has a E3 number, E3/1799, and it is from 1998. I believe, I don't have it now completely by heart, but he refers to other studies, including Vickery. So in his 1998 publication, he is quite extensive and incorporates all previous studies. So it would be the combination of his 1998 publication together with his 2015 publication, which should be the basis, I believe, for the summoning of him as an expert. Something that I haven't said, we have looked at his CV of Professor Huveline. I'm not sure if I'm correct in this, but it seems that his expertise in the demographics far exceeds the expertise of 2 TCE 93. Not only in general terms, but also in respect of his knowledge of Cambodia and DK.
President, you may now proceed. Mr. Co-Prosecutor.
Thank you, Mr. President. Just a couple of observations in response to this. First, I think it's important, particularly for the public, to understand why the total number of deaths during the democratic regime, while of immense, obviously, historical significance, is of limited legal significance to this proceeding. This is not a debate here about the legacy of the regime. I'd be happy to have that with counsel anytime this trial is over at Meta House. This is a legal proceeding. And the reason the trial chamber was discussing this issue in paragraph 174 of the prior judgment was simply for purposes of the chapeau element of whether or not there was a widespread and systematic attack against a civilian population during the regime. That is the reason this issue is discussed, and really the only issue to which the total number of deaths would have any relevance. I don't wish to engage in an argument here about the appeal. I think that any reasonable trier of fact here could reach no other conclusion other than that there was a widespread and systematic attack against a civilian population, and that depends. Conclusion in no way at all is affected by what the exact number is of deaths during the regime. That's obviously a consideration to have some sense of the scope, but the precise number doesn't affect the finding. We've heard there's indisputed evidence that there are security centers set up in every district, every zone, every sector around this country where people were arrested, executed without any legal process. Findings of DC Cam going around this country, mapping all the execution sites and security centers, the testimony and accounts of victims from across this country that are essentially similar. There are hundreds of facts that go into why there was a widespread and systematic attack against the civilian population. But it's important to understand that that is the only significant conclusion or finding that the trial chamber had to make here. So I do take issue with, obviously, with counsel's characterization of that finding, the findings in the judgment. With respect to the other expert, if the defense wishes to propose, I would ask that they do a filing. I'm not prepared, as I sit here, to have gone through all of Patrick Hevelin's prior work to see if he has done any analysis on the number of Chams and Vietnamese deaths. I think your honors are correct that that is, if we did have someone who had done work on that, that would be another issue. Obviously, I think both of us would agree here that if Ben Kiernan was available, he would be interesting to hear from. So I'm not prepared as I stand here to know whether Patrick Hevelin has done any research on that issue. If the defense wishes him to be called, we'll look at it and respond to any formal request on that.
President, thank you, Mr. Co-Prosecutor. And what about lead co-lawyers for civil parties? Do you wish to address the chamber?
Merci, Monsieur le Président.
Thank you, Mr. President. I would like to make a brief remark. I would like to rely on the discretion of the chamber regarding the discussion concerning Eva Tabo and the recent developments that have been presented in public session. I would nevertheless like to make a brief remark so that the chamber may be informed of our position and that the public may also be apprised of the position of the civil party. We know that Judge Fentz has said since the very beginning of this discussion that the number of victims, which is a historical matter of some importance, has no impact on the criminal responsibility of Nuon Chea and Khieu Samphan. The number of victims is not pertinent as regards crimes against humanity, war crimes, and also the charge of genocide against Nuon Chea and Khieu Samphan before this chamber. The number of victims in the genocide against the Vietnamese and the Cham is not relevant in order that the court may rule on the legal characterization of genocide. I understand that the Nuon Chea defense team is telling us that the total number of victims is important for its defense, but it is worth noting that from a legal standpoint, we are talking nevertheless of a trial, and we're participating in this trial. From a legal standpoint, that issue is not pertinent, so I would like the chamber to take that fundamental element into account and to weigh it against the interests of the civil parties who are bent on ensuring that the trial is expeditious. I say so particularly in regard to the motion made by the Nuon Chea defense team today with a view to calling Professor Hevelin. If I properly understood what he said as regards the figures, when we are talking of the deaths of ethnic Vietnamese and Cham during the Democratic Kampuchea regime, insofar as the number of victims does not have any incidence on the legal characterization of genocide. I thank you.
President, what about the defense team for Mr. Khieu Samphan? Do you have any comments to make?
Thank you, Mr. President. Indeed, I have a few. First of all, as regards the crux of the matter which brings us here today, that is the issue whether we would possibly support a request for the appearance of TCE 93. Let me remind the Chamber that in our submissions in E305/9, we were very clear in this regard. We were of the view that TCE 93 cannot be considered as an expert given her methodology and the contents of her work and lack of partiality. We cannot say the contrary today. The true issue, which is at the crux of our discussions today, is not so much to know whether she will appear or not, since I understand, if I read between the lines of the message she sent to the Chamber, and given the current conditions, she cannot appear. The real question is what you'll do with her report that is turned into evidence, E3/2414. If indeed she cannot appear and we cannot confront her on her methodology and the sources and the manner in which she has worked, it is obvious that the Chamber cannot consider her report with the greatest caution, and that the Chamber cannot give it any probative value. And this is all the more so the case because the prosecution has recognized it willingly as well. If I have properly understood the methodology used in drafting the report, TCE 93 has merely compiled data that existed and analyzed that data. Under those circumstances, it goes without saying that we can not but reiterate our position that her appearance, if it doesn't take place, in any case, or rather the absence of her appearance, can only give a very limited value to that report. One point that I would nevertheless like to raise is that it is very complicated to talk about figures when we talk of the number of deaths, because we should be clear on this, and I believe it is valid to both the accusation and the defense. One excess death is unacceptable, and it's excess to say that the number of violent deaths, the number of deaths doesn't have any legal value when we are looking at the elements of law that the Chamber has to take into consideration. I would like us to place things in perspective. Why? Of course, when we're talking of legal characterization of crimes, we have extremely precise elements that have to be factored in. In any case, as regards, for instance, the sentence that will be meted out to the accused if they were to be convicted, and also the notion of intent, taking into account the difference that could exist between different kinds of death depending on the living conditions, that would have an impact obviously on the discussions that will lead to the legal characterization, so that it is not something that is neutral. This is something very important. So the real issue that arises when we talk of demography and figures is what the Chamber will do with those figures. And as our colleague has pointed out earlier, referring to the figures given in the paragraphs dealing with the facts of the case in case 02/01, it is obvious that the figures have an impact on the manner in which the Chamber takes its decision. And it is so obvious, and it is not something that we should take lightly. It's not something harmless. In examination of witnesses, we always ask, was it so many people who died, and who took the decision as to the number of persons who are to be arrested? Of course, that has an impact. It is obvious that it has an impact. The real issue, in the absence of the appearance of a demographic expert as regards certain elements, is what the Chamber will do or not do with the figures that are provided and that are placed at the disposal of the Chamber.
President, please hold on for a few minutes because we need to change the DVD console. President, you may now resume. Counsel for Mr. Kirsanpan.
Je vous remercie, Monsieur le Président.
Thank you, Mr. President. So another element that I would like to raise as regards the issue of demographic elements is that we have other elements because in the announcement, if I understood correctly, we will have an expert to analyze certain execution sites. All that has an impact because and I mean from a legal standpoint, because these are evidentiary elements that are tendered before the court. When we criticize, for instance, the method used shortly after the fall of the DK regime in 1979, at the behest of the Vietnamese authorities, who became new authorities, and as regards the manner in which certain sites and security centers were used, is very important when we are holding a trial so many years after the facts. Because in 1979, everything stopped. We know everything didn't stop in 1979. Fighting continued and other acts were committed. So it's important to factor that in when we are talking of execution sites and pits in which remains of the dead were found. All these elements are part of the history of democratic Cambodia since 1979 and thereafter. All of that has an impact on the factual findings you will reach. Once more, all I can tell you on behalf of the Kirsanpan defense team is that what we have read in the report by TC93, although I have already said the name, all that what we have read shows that what she wrote is not of any probative value. To say that those figures will not have any impact on the legal findings or conclusions is wrong, because those, the report will have an impact on your legal findings. That is what I want to say at this stage. I don't want to go into any pleadings in a precautious manner because it is not the time to do so. But I would urge the Chamber to be extremely cautious when we are talking of figures. And if there are any expert reports or articles that would like to use as part of our discussions before this Chamber, we should be allowed to have the possibility of confronting the authors on their working methods and the factual elements they base themselves on. And if that is not the case, the Chamber will have to live with the consequences of the limited discussions before this Chamber and refrain from using the figures produced by authors without having exercised the due, the abundance of caution it needs to explain how these figures, as explained in its memo, are disputable. That is what I would like to say before this Chamber, bearing in mind the fact that our position regarding TCE 93 is the same as it was before, and that expert is not of any interest to the Kirsanpan defense team.
President, you may now proceed, Judge Lavagna.
Merci, Monsieur le Président. Bien.
Thank you, Mr. President. We have properly understood that the Kirsanpan defense objects to the appearance of TCE 93. But does the Kirsanpan team wish to call or have called another expert? We've heard the position of the Nyonchia team. What is the position of the Kirsanpan team? We have not made any request to that effect, Honorable Judge Laveng. So the only remark you are making is that the reports on record do not have any probative value in the absence of the appearance of their author. Is that what you mean? You're saying? Gise, that is correct.
President, the floor is given to Defense Counsel for Nyonchia.
Yes, thank you, Mr. President. Two things. It seems that we did indeed appeal the decision from the investigating judges. As a matter of fact, it also seems that we asked the Chamber on the 18th of May 2011 in E88 to consider this matter. That's one point. The second point is, I believe, also an important point, but hasn't been mentioned so far, but is related to this discussion of today, I believe, and that is the following. In the OCIJ's order rejecting the request for a second expert opinion, as I said, D 356/1, the OCIJ argued in paragraphs 7, 8, and 9 and 10 the following. It says, let me quote. It says, the co-investigating judge, in fact, the co-investigating judges gave due consideration to the possibility of organizing exhumations before finally deciding against conducting any. Then it says it was highly unlikely that forensic exhumations would provide any additional evidence that would be conducive to ascertaining the truth, whether exculpatory or inculpatory. And then it talks more about exhumation operations. Now, what is new, of course, is that since a few months we are aware of exhumation operations or similar forensic research or whatever you would like to call it, that has taken place in relation to both Chiang Ek and also to Krang Ta Chan. So we are now in the process of filing submissions in respect of the appointment of an expert, or whether this particular person who is in charge of Chiang Ek should be appointed as an expert, yes or no. But there is, of course, a very substantial new development since the decision of the OCIJ, and that is that forensic examinations have taken place, exhumation of 2 important sites has taken place. So that is something I think should be a matter of consideration as well, and this mere fact, I believe, is a substantial new element that would have potentially influenced the decision of the OCIJ. So that is something that I would like to mention and draw your attention to, Mr. President.
Sorry, might be a language issue, but I'm not sure if the 2 reports you referred to were actually due to exhumation. My understanding was that these were already existing skulls.
True.
Collected skulls.
Yes, that's my understanding as well, but they were counted, and one of the elements that is of great interest to the defense is whether the amount of skull and skeleton remains that were found matches the exhumation reports that have been also made by DCCAM. So we would have 2 very interesting examples of potential discrepancies between what is researched and found in the reports by DCCAM under the supervision of Etchison, and what has in fact been found by the people who have done this recent research. So that would be a very interesting new element, I believe, because that is something that directly affects the number of violent deaths that has been established in all these reports.
But again, back to the difference between it's interesting and what is legally relevant. This would, at best, allow to assess the number of deaths at a certain crime site or 2 certain crime sites. But how does this relate to the issue of overall excess deaths?
Well, in respect of S21, I understand your question, and probably it doesn't really have any legal effects. But when it comes to Krang Tachan, would it matter? It would certainly, I believe, matter to the way certain policies were implemented. If there's a very high discrepancy between the amount of deaths that is calculated and the amount of skulls that we actually find, that might say something about the policies that we are investigating.
No, that's a misunderstanding. I thought you made a case, among others, for the new expert by saying, and he should also look into the findings of these bone things. And the expert is supposed to talk about overall possible excess death. So how would that help? How would that work as a justification?
Well, all experts, they're all demographic experts, and they all rely on this exhumation project by DCCAM. They haven't actually gone to any of those mass grave sites and actually checked whether the findings in these reports were accurate. Now we might have two potential real exhumation results done recently. That would be, I believe, potentially a very interesting question for the expert to testify on. If there's a substantial discrepancy between the findings of the reports that they all seem to be relying on and the actual findings, then that might have an effect that would amount to a substantial reduction of the number of violent deaths in total.
President, Co-Prosecutor, the floor is yours.
Thank you. Just three more quick points. Obviously, the analyses of experts remain admissible before this court, whether they appear here or not. There is a wealth of people who've analyzed these issues. The value of the report that was done by TCE 93 was that it put this all together for the chamber and explained it. It cannot be said that this court cannot rely on the work of all these individuals that have been done on this issue of the number of deaths. And let me reiterate, whether you take the highest number or whether you take the lowest number of any of these people who've looked at this issue, it establishes beyond any question that there was a widespread and systematic attack against a civilian population. A second point, one of the issues that has brought us here today is whether TCE 93 should be called and have time to update her analysis based on the new report done by Patrick Heveland. Obviously, it would make more sense and be more expeditious for the court if it wants to look at the evidence of Heveland to call him himself rather than to have another expert spend a few months studying his work. So if we are going to hear if we are going to hear from someone on the issue of the total number of deaths, this new analysis by Professor Heveland, obviously the most expeditious way to consider this new evidence would be to call him rather than to have the previous expert spend months reviewing his work. And the last point, I just want to, I was about to say the same thing as Your Honor, Judge Fens. These were not exhumations that were done recently. The exhumations occurred a long time ago, and the reason that there simply is no issue about these bodies being from post-1979 conflicts is because when the people returned to Krang Tachan, to Kreng Cheng Ek, when they were allowed to return to their homes, they found these graves that hadn't existed when they were forced away from their homes in 1975. So there is really no issue on this point of post-79 killings. But the point counsel makes is actually an important one, because the contrast between the expert that the court is considering, someone who has done a study of the skulls that were recovered at Cheng Ek, is an issue directly relevant to this court, the killings of people from S-21. And obviously this expert was limited by the exhumations that were done back in the 1980s, which I believe were only two-thirds of the graves at Cheng Ek were exhumed at that time. And that is the remaining evidence that he had to work with. And apparently this same individual is doing an analysis with respect to Kreng Chen. That is entirely different, and obviously has an importance, immediate and direct importance, to the issues that we are trying in this court. So I just wanted to emphasize that as well.
President, thank you, Co-Prosecutor. Next, the Chamber will hear the oral submission related to 3 motion to admit document pursuant to Internal Rule 87.4 with regard to the testimony of 2 TCE 82.
Monsieur le Président, j'ai compris.
Mr. President, I understood that the Chamber had requested the parties to state whether they were ready to respond to motion Rule 87.4 disclosed yesterday, and we had to respond this morning. The Kyo Sampan team would like the Chamber to note that we are not ready to respond to that motion. I believe that we'll be able to do so on Monday morning. I wanted the Chamber to take stock of our position. I understand that the next expert is arriving soon, but I believe that on Monday morning we'll be in a position to have taken full cognizance of the motion and to make any relevant submissions. I have not had the opportunity to look at all the documents in the few minutes I've had and to make any reasonable submissions on them.
President, the floor is given to Defense Counsel for Nunjia.
Good morning again, Mr. President. It's just a quick word to say that we're in the same position as the Kyo Sampan team. We just received notification of this yesterday. We've been preparing the witness and we've been in court this morning. We're not in a position to make submissions at this time, but on Monday morning we think that would be acceptable.
President, what about the Deputy Co-Prosecutor?
Good morning, Mr. President. Good morning, Your Honours. The prosecution would be able to respond to these today. However, if the defence are responding on Monday, perhaps it may be better to do them all together, but we're in Your Honours' hands.
President, what about the lead co-lawyer for civil party?
Merci, Monsieur le Président.
Thank you, Mr. President. would like to inform you that we received the documents yesterday in the afternoon. So we should be able to respond to the arguments now, this afternoon, or Monday, as the defense has requested, as you so wish.
President, it is now time for lunch break. The chamber will adjourn the hearing now and will resume on Monday, 5th September 2016 at 9 a.m. The chamber will on Monday hear the motions in relation to Internal Rule 87.4 and also we'll hear the oral submissions in relation to 2 TCE 93, said the President. Security personnel are instructed to bring the two accused, Nunji and Kisampon, back to the ECCCC detention facility and have them returned into the courtroom on the 5th September 2016 before 9 a.m. The court is now adjourned.